Welcome back, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm the founder and CEO, also the host of the podcast, Rich Lenkov. We have Mitt Winter from Kenny Hertz Perry, who specializes in sports law, writes a great has a great column on X, writes extensively about sports law. Mitt, welcome to the podcast.
Thanks for having me, Rich. Appreciate it.
So one of the most significant settlements coming out of college athletics in some time is the House case. You've written extensively about it. It is going to have wide-reaching implications for college athletics. Explain to us maybe some history, briefly, what led us to that House settlement before we get into what has been agreed to in that agreement.
Yeah. So as you mentioned, we've kind of been building towards this House settlement for, I would say, around 10 years now. A lot of your listeners, viewers are probably familiar with the O'Bannon case, which is a case that the NCAA lost in 2014. It was another antitrust case, like the House case, related to college athlete compensation. That case actually dealt with use of college athlete name, image, and likenesses in video games, and the court, which is the same court, the same judge as House, found that NCAA rules that say college athletes cannot be paid NIL compensation at all from any party violate antitrust law. At that point, college athletes still were not able to monetize their NIL. It wasn't until 2021 that happened, but that was really the first case where the NCAA's athlete compensation rules were found to violate antitrust law. Then move forward, we had the Alston case, which was another big antitrust class action brought against the NCAA. Same court, same judge that heard O'Bannon and has House right now. And in that case, the court again found that some of the NCAA's athlete compensation rules related to educationally related benefits and expenses also violated antitrust law. That case was appealed up to the Ninth Circuit. The decision was appealed to the Ninth Circuit. Ninth Circuit affirmed the trial court decision. And then, probably a bad decision by the NCAA, they appealed that up to the Supreme Court. At the Supreme Court, they lost 9-0. So at this point, now you have a Supreme Court decision basically calling into question all of the NCAA's athlete compensation limits as potential antitrust violations. So that brings us to the House case now. The House case kind of...
Before we jump into that, sorry, what was the sort of core argument as to why this did violate antitrust laws, Mitt?
Yeah, it's because you have competitors, which are the schools, getting together via the NCAA and setting limits on the amount of compensation that the athletes can receive. So it's basically schools colluding to limit and price fix athlete compensation.
And while, I think the argument is made in a vacuum, how impactful is the fact that the NCAA is making, and these schools, in fact, are making literally billions of dollars, right, off these sports? I mean, that's got to have a big impact, even though technically that shouldn't be a large relevant factor. It's got to be impactful on the decisions, right?
Yeah, definitely. So for a long time, the courts, they bought the NCAA's arguments that we're college sports, these athletes are amateurs, so you need to look at us differently than you look at other businesses when you're applying antitrust law. Well, over time, when you get into the mid 2010s, when you have the O'Bannon case, and then 2020s with the Alston case, college athletics revenue exploded in those years. And although, like you said, it's not really supposed to be part of the antitrust analysis, I think it definitely played a factor. Even in the Supreme Court's Alston decision, it's mentioned the amount of revenue that's being generated by college athletics. So that definitely played a part in some of these decisions, I think.
So bring us to House. Who brings House, and where is that brought?
Yeah, so House kind of builds off of O'Bannon and Alston. It attacks the NCAA rules that say schools and conferences cannot directly pay NIL compensation to their athletes. And it's really trying to get at what they call broadcast NIL. So basically payments to the athletes for use of their NILs in TV broadcasts, because that's where the giant amounts of money being made in college athletics are from TV contracts, which are generally between conferences and broadcast networks. And a lot of that money is for football, a good chunk for men's basketball, and then some for some other sports as well. So that's what the House case is about. And it was arguing that those rules that say schools and conferences can't pay that NIL compensation directly to their athletes violate antitrust law. As part of the House case settlement, there are two other cases that have been wrapped into settlement discussions and now the settlement terms that have been agreed to. One is called the Hubbard case, which is basically trying to get at back damages that athletes were not able to receive, which what are now known as Alston payments that came out of the Alston case. Schools are now allowed to pay $5,980 per year to their athletes, basically for their academic performance as an academic incentive and award. And so a lot of schools make those payments to their athletes now. So the Hubbard case is saying, well, athletes in the past that were not able to receive these Alston payments, they should be compensated for their damages, because the Supreme Court found that the rule that didn't allow them to get those payments violated antitrust law. So that case has been wrapped into House. And then there's also a case called the Carter case, which is wrapped into the House settlement as well. And that case goes farther than House, because it's arguing that the NCAA's rules that say college athletes can't be paid for their athletic performance, not just for use of their NILs, violates antitrust law. So Carter case really just attacks all of the NCAA compensation rules that try to drive a distinction between college athletics and pro athletics. So those three cases have all been wrapped into the House settlement, and the NCAA, Power 5 conferences, and the plaintiffs' attorneys have now agreed on at least the terms of the settlement. And the House settlement really has two big components. One is a back damages component, which is around $2.8 billion that's going to be paid to some former and some current college athletes. If you were a Power 5 college athlete, men's basketball, football, women's basketball, between 2016 and 2023, you're eligible to receive some of these, this $2.8 billion in back damages. And then if you're another Division I athlete that played any sport at any school who did receive some NIL compensation after 2021, you're also potentially eligible for some of these back damages. So that's one component, that the $2.8 billion in back damages, that's a backwards-looking component of the settlement. Then you have the forward-looking component of the settlement where, assuming the settlement gets approved, schools will be able to directly pay NIL compensation to their athletes, which is a big change from how college athletics has operated for a very long time. Kind of that line in the sand for the NCAA and schools is schools cannot pay their athletes. Well, probably starting fall of 2025, college universities will be able to directly pay their athletes. They're going to still call it NIL compensation, but I don't know. It's kind of semantics. Is there really any difference between paying your athletes NIL compensation versus athletic performance? It's really a fine line there. And on one other thing to mention on the revenue, people are calling them revenue share payments, these NIL payments that schools will be able to make. There's going to be a cap of $22 million that each school will be able to pay annually to all of its athletes. So the football team, men's basketball team, women's basketball team, softball team, baseball team, rowing team, every athletics team, there will be a cap of $22 million total that can be paid to all of those athletes.
So these numbers sound like a lot of money, Mitt, the 2.8 billion, the 22 million, but in reality, again, given the landscape of the money we're talking about, it's really just kind of a drop in the bucket, isn't it?
Yeah, it kind of depends on your perspective. The way that they came at this $22 million, they tried to, when you include the scholarships that are being paid to athletes, plus some of this TV revenue, they tried to arrive at a number that they said was about 50% of the revenue. And that $22 million is an average for Power 5 schools. So it's not going to be 50% at a place like Texas or Ohio State where they have a lot more athletics revenue, but it'll be 50% at some of the schools. And one other thing, it's not like all of the revenue or all of the revenue share payments are not going to be going to the football players when the football players are generating the vast majority of that revenue. So in a lot of pro sports, it's about a 50-50 split between the teams and the athletes. So they sort of tried to approximate that, but it's not really going to be a 50-50 revenue split like you see at the professional level.
And Mitt, remind our listeners and our viewers what the Power 5 is and explain why only the Power 5 is affected by the House settlement.
The Power 5 conferences are the SEC, the Big Ten, the ACC, the Big 12, and the Pac-12, which doesn't technically exist as the Pac-12.
Former, right.
Yeah. But so those 5 conferences, in addition to the NCAA, were the defendants in the House case. So that's why they had to sign off on the settlement as well. Moving forward, the settlement's going to affect most likely all of Division I. It's sort of unclear right now how that's going to happen, whether schools outside the Power 5, Power 4, I guess now, are going to have to opt in to this revenue sharing plan, or if they'll just automatically be able to pay their athletes up to this $22 million cap, or if the P4 is now just going to be in their separate division and no one else will be able to be in their little division that can pay NIL compensation to their athletes. So it kind of remains to be seen how that's going to work out. But it's most likely that at least FBS football schools and probably all of Division I will be able to make these revenue share payments.
Mitt, last question we have for you today is this is a settlement, still has to be approved by the court. Any chance that this does not get approved?
I mean, there definitely is a chance. There's always a chance when you have these big class action settlements like this and you have a lot of absent class members. The court wants to make sure it's fair for those absent class members. And there is one unique part of this settlement. They're trying to prevent future antitrust lawsuits like this from being brought in the future by future college athletes who are not part of the class. You're only a class member in this case if you're a former or current college athlete. So if you're in high school now and in a year you become a college athlete, you could bring your own antitrust lawsuit against the NCAA and the conferences because your compensation is still capped. The cap on payments from schools to athletes used to be 0. Now it's going to be $22 million. So there's still a cap there, which is problematic under antitrust law. So in this settlement, they're trying to build in a process where future college athletes are automatically opted in to the terms of the settlement. So if you opt in, say, I agree, I'm not going to sue you in the future for violating antitrust law under the terms of this revenue share model that we have. It's sort of a novel aspect of a settlement. I've talked to lots of people. No one's really heard of a thing where you're automatically opting in people that aren't class members into the terms of the settlement. So the court might have some questions about that. Another potential hiccup that could happen is, so when the court's approving this, it has what's called a fairness hearing where people get to show up in front of the court and say, here's why this settlement is not fair. I don't think it's fair. So it's possible that some college athletes that are members of the class show up and say, we don't like this settlement, still caps our compensation. So if there's a lot of athletes that do that, that could give the court some pause on approving it as well.
Breaking down the very important settlement in the House case, that's Mitt Winter from Kenny Hertz Perry. The website is kennyhertzperry.com. Mitt, thanks so much for joining us on the SERMAPod, and please come back and keep us updated on ongoing developments in this and other areas of sports law. Appreciate it.
Yeah, thanks for having me on. And I don't think there's going to be any shortage of legal issues in college sports for the foreseeable future. So we'd be happy to come back on sometime.